Court will note the appearance then of Ms. Ootman on behalf of the plaintiff, Ms. Green on behalf of the defendant. This matter is before the court on the defendant's motion to enforce judgment of divorce, compel payment of spousal support, modify child support, make up parenting time, and defendant's motion to compel production of documents and for, again, concerning in-person work. So defendant, you can proceed.
Thank you, Your Honor. Good morning. Yes, so we have several issues before the court. Your Honor, would you prefer I address each issue or would you like me to just go through them all now?
Go through everything and then we'll go to Ms. Ootman.
All right. So on the issue of personal property, the last time we were here, Mr. Klein had suggested a wash. Both parties had outstanding personal property that needed to still be exchanged. And we ended up not doing that. We had an exchanged upon personal property day. Mr. Klein brought all the property that he had to the exchange. Ms. Fogles didn't bring any property. Mr. Klein also went, and any property he didn't have, he paid Ms. Fogel the cash value, or he purchased a brand new, set of pots and pans and plugs for the cars. So he brought all the property that he needed. He hasn't received any. On the issue of child support, it's undisputed that Mr. Klein has an overpayment amount of $1,814. We've reached out to the friend of the court and asked that that be paused to allow that child support payment to catch up. The friend of the court said they weren't able to do anything without an order in place to pause that order for income withholding. So I guess alternatively, Ms. Fogel can pay Mr. Klein that overpayment, but we're just proposing that that order for income withholding be paused to allow the child support payments to catch up. Related to child support, Mr. Klein believes that there has been a change in income to Ms. Fogles' income since she moved. She has historically always gotten a raise every time she moves locations. And the last time the child support was calculated, it used her 2023 income, or, at the end of 2024, beginning of 2025, believes there's been some significant bonus and an adjustment to her income. In addition, there's currently a $170 child support credit for daycare costs that are being included. Mr. Klein hasn't received any verification that the child's attending childcare right now. That number was from a Michigan child support provider. And Ms. Fogel has also moved state, so that income tax is lower in Indiana and should be reflected. On the issue of spousal support, Mr. Klein currently is owed $1,589.65 according to his misdue calculation printout. And so he's still owed that spousal support amount, and he's asking for that money to be paid. On the issue of parenting time, this summer, Ms. Fogel moved to Indiana, and when she moved, there was no parenting time in place. And before, Mr. Klein had been exercising a Tuesday parenting time from 4 to 8 p.m. as well as a Thursday to Sunday. With the child starting school 3 hours away, that Thursday parenting time, ended. It wasn't realistic to think that Mr. Klein was going to have, Thursdays 3 hours away during the middle of the school year. As a result, there was a period of a lot of parenting time negotiation and transition, trying to figure out what this new parenting time was going to look like, as well as where the exchanges were going to take place. In this interim time, Mr. Klein had proposed, we should be following the order that we have that the court can enforce. And that was not agreed upon. And as a result, there was a lot of back and forth. Long story short, Mr. Klein did not have his parenting time on the weekend of September 27th to 29th because Ms. Klein would not agree to the exchange location at a midway point and said he could either come down and get the kid or he wasn't going to see him. So he is asking for and make up parenting time for that one weekend. Finally, the last issue we have is the production of documents. As part of the party's consent order, they did eventually come to a parenting time consent order. Ms. Fogel is required to produce documentation that she can work from home. We got the generic, company-wide policy that says you can be, in person or you can work from home under all these conditions. So it didn't really narrow down what Ms. Fogel's classification is. We're asking for any screenshot, email from HR, anything that can just verify that she's able to work from home. So those are the issues that we have before the court today.
Okay, thank you. Ms. Ootman, I have reviewed your answer.
Go ahead.
I said, go ahead.
As we filed our responses, I would like to stand on those responses as filed, but just for the sake of the record, I would like to point out that there was no outstanding personal property that was ordered to be returned to Mr. Klein that had not already been returned to him far in advance of the exchange that occurred as a result of the court's last order on the personal property issues. As far as the child support order, we have no objection to a pause on the income withholding. However, my client is not prepared to make those payments to him directly. So that could be paused to catch him up, or rather give him that credit. As far as the daycare, the child is attending daycare, and that is appropriate to have continued in the child support order. She did not, Ms. Klein, or Ms. Fogel rather, did not receive any increases in her wages as a result of the move. Historically speaking, she has had raises in the past, but often, as noted in the trial, with these parties divorced, she has made many lateral moves, which did not result in any significant bonuses or increases in income. As far as the income tax, we don't dispute that there is a difference in the income tax for Indiana versus Michigan. However, I don't think that is appropriate to request child support review after the parties entered into a consent child support order so recently. As far as the spousal support, it's our understanding that if the front of the court records were looked at for current Ms. Fogel's income withholding order does span over the months at sometimes because of her pay structure, and she is current. There is no back or past due spousal support due to Mr. Klein at this time. As far as the parenting time goes, there was a consent order that should prevail. These parties did not miss any parenting time unless it was by choice. Mr. Klein did not give any advance notice to his desire to have Ms. Fogel bring Dakota up to Michigan on the weekend in question. And the fact is, he told Ms. Fogel at the last minute, with no time to get Dakota where he needed to be, that he wasn't going to drive. As far as the production of documents, the work policy was provided. The work policy is specific. Ms. Fogel did not meet any of the requirements in that policy to work from home. And so what we submitted to Ms. Green should be sufficient. We're against any further discovery because this is a done issue. These parties entered into a consent order, and the move was made with Ms. Fogel having sole legal custody, and the parenting time was modified. And as far as we can tell, this should be a done issue, and my client feels that this is just an ongoing effort to keep the litigation going. In our response to the motion to enforce filed by Attorney Green, we did ask for approximately $10,000 in payment for the items that Mr. Klein did not provide, and we are asking for attorney's fees, and we are asking for contempt of court against Mr. Klein.
Okay. Well, in this matter, the court's again reviewed all the files, heard the argument now. As it relates to the personal property that's in dispute, the court would direct defendant's counsel to review the May 25, 2023 order, as the court had previously ruled that the court would not address property not ruled on. Rather, that property would remain with whomever has it in their possession. And so the court is going to continue to enforce that order. I am not going to, again, address anything on additional personal property that wasn't contained previously and wasn't addressed by that May 2023 order. Court believes that in this particular matter that, again, there's speculation as to whether her income has increased. It says, well, and historically, when she's relocated, she's got an increase. There's no evidence that she has, and the court's not going to modify child support based upon speculation as to what somebody may be making. If you have evidence that that's changed and it justifies a modification, the court would consider it, but I'm not going to do it based upon pure speculation. Although the court would note that in this matter, there's no dispute that the child is not in child care now. And so what the court will order is that the defendant's support would be decreased by the $27 per month that was his contribution to childcare that is no longer being made. Court would further order, as Ms. Oatman had agreed, that she would have a problem with suspending the support until the $1,841 is extinguished. So the court would order that, again, that child support obligation would be suspended until the $1,841 is extinguished. As it relates to spousal support, that is through income withholding. And as Ms. Ootman states, it's current and it might be changed because of the way it's collected or taken out and remitted, but the court isn't going to address that. It appears that that's being taken care of by the current order. The court will order, and I didn't know from the pleadings or argument, the court would order that the child would be exchanged at a halfway point between the parties' residence. They can pick that point as to the exchange. If they don't, then you can bring the matter back before the court. The court will not award attorney fees in this matter to either party. And I'll ask Ms. Green that you would prepare that order consistent with the court ruling, submit under 7 days.
Thank you. Your Honor. One question. I don't know if we addressed the production of documents.
I'm
Time.
not going to order that. Apparently, the documents relating to that in-person work were exchanged. If you have something else that would determine or designate that otherwise, then you have a right to file a motion on that. But again, it's just at this point, it's just speculation, and the court's not going to make a ruling based upon speculation. Yes, Ms. Oldman?
Yes, Your Honor, I had 2 points that I wanted to clarify. The daycare, the child is attending daycare. Are you going to order that decrease in the child support?
Oh, I thought that you had confirmed that the child through the pleadings was not in daycare.
No,
Well,
he is.
If the child's in daycare, that will continue, then we will not modify the support on that basis.
Okay, the other point that I wanted to ask about is the amount that we requested in our request for relief for the items that Mr. Klein was ordered to provide and did not.
Well, as I said, the court will enforce the order. And what you're going to have to do is I'll let you notice up an order to that extent. And then if Ms. Green wishes to object, she can object, and then we will address that.
Very good. Thank you, Your Honor.
Okay. Thank you. You're free to go.
Your
Have
Honor,
a good day.
Your Honor, sorry, I don't think we addressed the makeup parenting time. Was there a ruling on that?
I'm not going to address the makeup parenting time.
Okay, thank you. We'll prepare an order.
Thank you.
Thank you, Your Honor.
Megan Gorham versus Storm Goodell.
Court will note the appearance of Mr. Bartell on behalf of the plaintiff and Ms. Sawyer on behalf of the defendant. This matter is before the court on the plaintiff's motion to show cause why the defendant should not be in contempt, to suspend parenting time and return the child in this matter. Mr. Bartell.
Thank you, Your Honor. With this matter, as we had detailed, that the defendant in this matter unilaterally decided to take the minor child out of school from the Penfield School District, and that minor child has not returned. There was an investigation, though, by CPS. There was an investigation by the Calhoun County Sheriff's Department. There was a CIT interview done in conjunction with the prosecutor's office. That matter has closed out, Your Honor. The CPS, the Calhoun County Sheriff's Department, and the prosecutor's office has determined there is nothing in this particular matter that has transpired. They have closed out their investigation. They have closed out their case. I had also provided a couple exhibits that are attached to the motion, and in particular, Exhibit 2. It was by the CPS worker in this case, in which she had indicated to the defendant that the minor child needed to go back to school, and he still has not returned the minor child to school. It appears there may be some truancy issues coming up with Penfield schools in relation to that. Further, the CPS individual had indicated in that group text that parenting time needed to resume. And it's, I understand this court always get stories from attorneys and from other individuals saying, well, CPS told me this or that or whatever. It's right there, Your Honor. It's in the text, clear from CPS, indicating that they were closing their case. Along with the detective that had worked on this particular matter, they have not found anything to substantiate what has been claimed in this matter, and that she should be able to resume her parenting time. I say that is very noteworthy because defendant's answer or response is not really much of a response other than to say, I believe my child and we need an investigation, even though we had 3 different departments that did an extensive investigation that went for well over a month, and they didn't find anything here, Your Honor. It is just defendant. I mean, I don't know what investigation they want done. Further, Your Honor, I can provide it to the court. I do not like them as attachments, but there are therapy notes from a couple years ago in which the minor child had divulged to the counselor at that time that father was telling her what to say. I think that is in fact what is happening here, unfortunately. He has a history of that. He actually has another matter with, he has other children with another party in which he has issues going on that are very similar as well. Your Honor, he should be found in contempt. It is clear as day with the text messages and the information provided to this court. He should be held in contempt. My client should be able to resume the parenting time. The child should go back to Penfield schools. If anything, Your Honor, I believe he should have his parenting time suspended. You know, it's clear that he is not working in the best interest of the minor child, and I believe that is warranted in this matter. Thank you.
Mr. Bartel, how many days of parenting time were missed?
Oh, shoot, Your Honor. I guess I apologize to date. I can try to calculate them for you, Your Honor.
Okay, we'll let Miss Sawyer go, and then maybe you can get that number to me. Okay, Miss Sawyer, what's your response?
Your Honor, our response is basically that they are not giving you a complete factual record of what's occurring here. And while there have been correspondence with CPS where CPS initially told them to return the child to the Penfield schools, or initially said to resume the parenting time, there have been numerous texts since that time, and that including the one text and not the complete record is why we would need to have some sort of evidentiary hearing here. You can't just say this is the one text that it had without the complete record of what's going on, and anything that's happened subsequently. Our position is that the Penfield schools are well aware that the father was going to pull her out and put her in virtual homeschool where she's maintaining a 3.8 grade point average. Our contention is that their initial filing was way off base in terms of the father feeding her the information. The child on her own went to the dean of students at Penfield schools and reported that this abuse was occurring. Prior to that, father had never had any conversations whatsoever about abuse in that household. He didn't coach her. He didn't tell her to go to the school. She didn't come to him first. She went to the schools first. And the reason why we would want an evidentiary hearing is, of course, because we can have the dean of students of the school, who is the one who went to father with the concern, come back and testify to that. And the dean of students at the school also said, hey, listen, your child has come to us and said there's abuse happening. And also we have on our own had some concerns about the way that the child appears when she's been at mom's. We can tell the difference when she's been at mom's house and when she's been at your house. When she comes from mom's house, she sometimes appears wearing mother's clothing. She hasn't bathed. She's not talkative. She appears unhappy. When she comes from your house, she appears happy and well-adjusted. With regards to any truancy issues, there is a hearing. There was set to be a hearing where the father was going to address it. It was last Thursday, which was a snow day. That hearing is still going to take place, and he has assured Penfield schools that she is in virtual school, and they said that the only thing that they need is evidence that she's in that school where she is going and enrolled every day. She's got her 3.8 grade point average at that school. So it's not an issue. Again, these are issues that came up not from father. A therapy hearing from years ago saying maybe dad told her what to say. I don't think it's relevant. I don't think it's relevant here, is particularly when you're talking about something that happened years ago. And I don't think it's relevant when we're saying she went to the school counselor on her own without ever having brought these issues up to her father before. I think certainly
Are
there's.
are you saying that these issues are brought up and CPS just ignored those?
No, what CPS, their contentions regarding CPS is very different than my client's contention. CPS
Well, if
said,
CPS didn't continue and they've closed their investigation, it means they haven't substantiated and they didn't have any further recommendation.
what they recommended to the father was that the father enroll her in a third-party counselor and continue to. They didn't say we don't find, it's proving a negative, Your Honor. They said we can't prove that anything has occurred, but we don't know that nothing has. That's what they told father, and they recommended to father that he enroll her in a counselor, which he's done through the Borges healthcare system. And he's done exactly what CPS told him to do. Nothing more, nothing less. He's not trying to add fuel to any fire that might be there. He is not trying to sway the child. He's doing exactly what the CPS worker told him to do. And we would be willing in an evidentiary situation to bring in the CPS so that the CPS worker can give her own testimony about what she told mother versus what she told father, and have the record. As it is, we're just standing on they're attempting to stand on one text message that isn't a complete record of what happened. And it's not father's contention that CPS said, oh no, we've closed it. It's father's contention that CPS said, hey, get her into a counselor. And what we have asked for in our response is, I think, the logical thing, Your Honor: appoint a guardian ad litem, assign a guardian ad litem to the case, have it paid for by the court, and let that person be a neutral fact finder in terms of what's going on here. Our concern is that they're just trying to get everything dropped and get it on the record. And this is a case I'm not sure why it would be relevant that he has a pending custody proceeding with his other child. There's no allegations of malfeasance in that case. It's just that they've never had a custody order in place. But what I can say is that this particular mother has been to the court every year since 2018 trying to get custody and parenting time changed. And every single time it's gone in father's direction. If we have an actual proper evidentiary hearing, if we get a guardian ad litem appointed, we're confident that at a base minimum, we can figure out what the problem is here.
Well, I don't think we need to appoint a lot of people in this matter. If the child's going to a counselor, the counselor can make, again, do a report and make a recommendation. That wouldn't be much different than maybe the guardian ad litem. So I'm not going to just load up and have multiple other entities involved in this proceeding.
And we'd be perfectly happy with the counselor being the one who makes a report, as long as both sides agree to the fact that what the counselor says is not deemed to have been at father's behest, because we will go ahead and admit that we're the ones who picked the counselor. So if we need to pick I would say that a counselor through the Borges health system is not going to be somebody who's biased in our favor. But if that's going to become a problem, then we would say that maybe, okay, we'll go back to the drawing board and get a different counselor, or we're both going to have to agree to the counselor. We're fine with it being the counselor. We just don't want to hear about it later that we're the ones who picked the counselor.
Okay. Anything else, Mr. Bartel?
Yeah, and I'm going to give you my estimation is 35 days have been wrongfully missed here. I would just want to really quickly respond. I'm befuddled by the argument of defense side. I mean, quite frankly, we have an investigation. They want to bring the CPS person in as to what was said and what was not said between that period. But we actually have a text message from CPS saying we're closing it out. It hasn't been substantiated. We have detectives involved. We have CPS involved. We have a CIT where the child said nothing happened. And yet they say, we got to get to the bottom of this. That makes zero sense. It makes no sense. I just want a do-over because I want to keep trying. I want to keep trying. And essentially you're saying is that CPS Calhoun County Sheriff's Department, the prosecutor's office, CIT interviewer, they're not good enough professionals here. Okay. I mean, what a bunch of hogwash here. And what we need here is to continue forward as to what my client was should be getting with regards to parenting time. And if anything, like I said, this shows that defendant father just doesn't want to abide by anything. He unilaterally also put the kid into a counselor, and now he wants, well, I want that counselor now to get involved as well. That doesn't make sense, Your Honor. I hope that this court would give us the relief we're asking, as this is as clear as day. They just want to keep pushing this forward in a different direction that they're hopeful will be in his favor, even though it's not, since we have the finality of all the professionals here.
Okay.
Your
Well-
Honor, just if I can respond really
No,
quickly.
I don't
to
need
that.
anything else. I'm
Okay.
sorry. What the court's gonna do is order that the child would go into counseling. And what I'll do is that they would go to a counseling that's mutually agreed by the parties. If you can't get an agreement, then you can bring it back on a motion, but the attorneys obviously are aware of who the counselors are. They should be able to come to an agreement. If they can't, bring it back and the court will appoint a counselor at that particular time. Court will reserve the other issues, contempt, etc. And that for a later hearing, I'm going to refer it to a referee. You'll be able to get into a referee much sooner than you'll be able to get into me. The court will, in this matter, order that the child would be returned to Penfield School forthwith. Again, I understand what the defendant has stated, but there is joint legal custody. It was not agreed upon, it was not discussed, and therefore the child will be returned to that particular school forthwith, which means tomorrow the child will be returned to Penfield School. The court will reserve on attorney fees in this matter. The court will order likewise, what was the parenting time prior to its cessation, Mr. Patel?
They had a different set, but it was roughly 50-50, Your Honor. But there was like
that particular days, alternating weeks, what?
It was particular days, Your Honor. Ms. Gorham, what were the specific days?
He would get Monday through Wednesday. I would get Wednesday through Friday and alternate weekends.
Okay. The court will, again, the court will continue that parenting time commencing this week. So the defendant has his Monday through Wednesday. She'll get the child on Wednesday, and then we'll continue that arrangement. And the court will reserve on the, again, the makeup time too, pending, and have that heard by the referee as well. Okay, Mr. Bartel, I'll ask that you would prepare the order, submit under 7-day.
Okay, well, thank you.
Okay, thank you.
Thank you, Your Honor.
Luke Spring versus Zone Par.
Court will note the appearance of Ms. Paisno on behalf of the defendant. This matter is before the court on the defendant's motion for contempt, reintegration therapy, and counseling. Go ahead, Ms. Paisno.
Your Honor, I'll be brief. This is not the first time we've been before this court on this specific issue in regards to having Mr. Spring move forward with these previous court's order. Back on July 29th of this year, this court ordered that the children were to continue at Avalon Behavioral Health and that appointments were supposed to be made by both children, or for both children. I did recently send a subpoena to Avalon asking for an update. They indicate that from a letter dated December 6th, they had released or terminated Lucy from therapy because it had been over 90 days with no contact from Mr. Spring or any appointments in relationship to Lucy. It does indicate that Dad reached out finally on December 2nd and scheduled an appointment for Lucy, but there still are no appointments scheduled for the minor child, Maria. They did indicate that there was a little bit of conflict in relationship to scheduling Maria with the same therapist, but it seems that there has been very little effort in getting Maria into the counseling. I will update the court that when I filed the original motion, Dad had not reached out to Rebecca Walker, who was supposed to do the reintegration. It's my understanding over the weekend, Ms. Walker indicated to me that She did meet with the children last week for the first time, last Wednesday, for the first time. However, she was going to be reaching out to my client to set up to move forward on that. What we're asking for, and at the time I filed this motion, nothing was taking place, is that Mr. Spring follow through and set consistent scheduling for these minor children, or have this court just set the matter for an evidentiary hearing, so this court can hear from what little they may know, to have my client out of Family and Children's Services and actually have parenting time with the minor children. If this court does not want to set it for a hearing, we would ask at this point in time, due to the consistent delays of Mr. Spring, that unsupervised parenting time take place now.
Okay. Mr. Spring, what's your response and why did you not get the counselors involved until after the motion was filed?
Your Honor, I first want to say that I didn't receive a single phone call from Ms. Parr or from Ms. Pezzo about anything about this. I could have cleared this up with a single phone call, but they didn't even try to
clear it up
call.
now.
Yeah. Okay, so Lucy has been seeing the therapist for over a year now. There's only been a couple cancellations with appointments and things like that. We always reschedule. She was supposed to see the therapist on Saturday, but then the counselor was sick, so we had to cancel again. So things like this come up. That's why there was a break in the counseling. I have been contacting Mrs. Walker about the counseling with the children and Miss Parr. We've been going back and forth. We've had 2 meetings. We have to schedule them out. So that's why I've made all the phone calls, made all the appointments before the deadline. So I'm not breaking any type of order. There isn't anything against the order that I haven't done. And I'm scheduling a appointment with my other daughter, Maria. We just have to line up a counselor. We're waiting for Catherine Salas to give us a referral for what type of counselor she would think. Hopefully we can do it in Avalon, but she might have to refer a counselor outside of Avalon that specializes with children. So.
Okay. Can you get that set up within 30 days?
I can do that today.
Okay.
I was planning on doing that on Saturday with our appointment with Catherine Salas, but then it got canceled.
Okay.
By her.
Well, what we'll do is order, you can do it. I'll put in that you'll have that set up with Maria within 10 days of today's date, that you'll notify Ms. Pazno as to when that is. That Ms. Pazno, you have opportunity. Apparently, if Lucy's been in for over a year, you should be able to get records showing she's been going for a year.
Your Honor, she went for years. She didn't go for 90+ days. That was the issue. She hasn't been going consistently. That was what they told me. I do have some records, but nothing recent because she hasn't gone.
What about that, Mr. Spring? Yes, she hasn't gone the last 90 days.
Appointments have had to get rescheduled, both because of me and because of the counselor. So she schedules things out 3 weeks at a time. So getting an appointment sometimes takes a little bit longer than it gets canceled. We can't do it and then we got to reschedule. So that's why it took 90 days.
Okay.
I haven't told them that I'm not coming back or anything like that.
We'll get that rescheduled within 10 days of today's date as well, and provide Ms. Pazno with that information. And the court will reserve on any additional relief at this time. Ms. Pazno, you can prepare an order and submit under 7 days.
I can do that, Your Honor. Thank you.
Thank you. Free to go. Have a good day.
You too. Thank you.
Daniel Hind versus Nikki Hind.
Court will note the appearance of Ms. Capture on behalf of the plaintiff, Ms. Coffin on behalf of the defendant. We have 2 motions. We have plaintiff's motion to amend the UCSO to reopen discovery for psychological evaluations, and defendant's motion to establish interim parenting time and child support. I think, why don't we go with plaintiffs first and then we'll proceed from there.
Judge, so we have stipulated on a judgment of divorce. We have a consent order. We also have stipulation to take proofs today if the judge, if you're willing to allow us to do that. We're also requesting that we waive the statutory waiting period. We have not yet gotten in front of the court approval because this all happened last week, late in the week. So, but we are hoping that if we preserve proofs today, that upon getting in front of the court approval, we can sign this judgment and have these parties divorced before the end of the year.
Okay, and why should the court waive the waiting period?
Your Honor, the reason that we're seeking for the waiver of the waiting period is that these parties have already been separated for over 6 months. We're requesting that because of tax purposes, this year would end then at 2024, and the parties will be able to file for taxes beginning 2025 as separate entities.
Okay, Ms. Cochran, what's your position on that?
Is that we did sign the consent judgment of divorce and the consent uniform child support order, the final version. We had also prepared, and I believe that it was going to be filed last week, a joint uncontested motion for waiver of the statutory waiting period, along with the stipulation to take proofs. Within the joint motion that we'd prepared, I don't know if it, I guess I had expected was going to be filed, but the snow days and everything was kind of crazy, I guess. That we do agree that for tax planning purposes, the parties believe it's necessary to have their divorce finalized prior to the end of December. And also the parties' agreement relating to the refinance of the mortgage associated with the marital residence is based on the date that the judgment is entered. That's in, I know you don't have it in front of you, but it's in section 6.4B3 of the judgment. So there is a financial necessity for finalizing the divorce action in December of 2024, rather than waiting until the January 25th, 2025 expiration of the statutory waiting period. Furthermore, the parties' uniform child support order that the parties have agreed to does having that entered contemporaneous with the judgment in December will expedite the payment of child support as is necessary therein. So we had been hoping that this matter could be finalized, but today, or at least having proofs preserved, contingent, or I guess timing wise, dependent on when the front of the court can approve the judgment.
Okay.
We did include a provision in the judgment, and we had tried to be prepared, right? All of us together trying to, there is a provision in the judgment for the granting of the motion, granting of the waiver of the 6-month waiting period, with the hopes that everything would be able to be filed together. But again, the normal natural delay of the front of the court, which is not like a delay, it's just that we settled last week.
Well, in this matter, obviously, as stated, by miscapture that, well, they've already been separated for 6 months, and obviously there's some financial issues. These do not satisfy the court rule as it relates to a waiver of the 6 months in this matter, nor the statute. So the court will not grant the waiver at this particular time, as again, the basis has not been satisfied. And obviously, if I were to do it in this case, I'd have to do it in every case, because everybody could say, well, we've been separated this long and we want to get this matter done before the end of the year for tax purposes. That does not satisfy the requirements for a waiver. So the court will not waive that. But I will take proofs in this matter. So, sir, I'm going to have you raise your right hand. We'll have you sworn in and we'll take some testimony.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Ms. Capture.
Thank you. Dan, can you please state your full name for the record and spell your last name?
Daniel Jefferson Hind, Hinde.
And what is your present address?
210 North Kalamazoo Ave, Marshall, Michigan.
And do you recall filing for a divorce in this matter?
Yes.
And at the time of filing, had you lived in Michigan for 180 days continuously and in Calhoun County for 10 days continuously?
Yes.
And were there any children adopted, born, or conceived during this marriage?
Yes.
And what are the names and ages of those children?
Murphy, she's 3, and Miles, he is 2.
And to your knowledge, is your wife currently pregnant?
No.
When were you separated?
June 30th.
2024?
Correct.
And do you know where your spouse is currently residing?
In Kalamazoo.
And you state in your complaint for divorce that there has been a breakdown of your marriage to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved. Is that statement still true today?
Yes.
And can you describe briefly to the court the facts on which you base that statement?
We were no longer in a working functional relationship.
And do you think there's any possibility of reconciliation?
No.
And in this matter, there is a consent judgment of divorce. Have you reviewed the property settlement agreement located within that divorce?
Yes.
And do you believe the terms are fair and equitable based on the circumstances that we've gone through with multiple mediations and negotiations with opposing party?
Yes.
And have you reviewed the custody, child support, and parenting time provisions?
Yes.
And do you believe that those are in the best interests of the minor children in this matter?
Yes.
And you have signed and dated that consent judgment of divorce.
Yes.
To your knowledge, do you believe that your wife would like her former name restored to her?
No.
Okay. You just don't know.
Yeah.
Okay. Thank you, Your Honor. I believe that satisfies the proofs here, and I think we're all set. Thank you.
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending, again, the running of the time, which will be later January. Once that time is run, the court will sign it. You're not divorced until I actually sign that judgment. But at that time, we'll get it entered and you will be divorced. Best of luck to both of you. I hope everything works out for you. You're free to go. Have a good day.
Thank you so much, Judge.
Courtney Morris versus Logan Morris.
Court will note the appearance of Mr. Robinson on behalf of the plaintiff, Ms. Jensen on behalf of the defendant. This is before the court on the defendant's motion to correct the UCSO to include healthcare provision in this particular matter. Go ahead, Ms. Jensen.
Thank you, Your Honor. Yes, this is a very, I feel, uncomplicated motion. And I did have a chance briefly to talk with Mr. Robinson on Friday and sent him the documents that I believe are prudent for this. As the court notes, there was a judgment and a UCSO that was entered. Within that UCSO, the calculations indicated, and my client does pay for medical insurance for the children and has for the period of the children's lives. And Ms. Morris completed that UCSO as she was pro per on that last part of the divorce. And I believe it was an inadvertent mistake not including that premium on the UCSO. Nonetheless, the friend of the court then adjusted what the child support was because that wasn't listed on the UCSO and ended up charging my client a higher amount for that. We did reach out to the friend of the court and were informed of what the mistake was. At that time, we reached out to Ms. Morris since she was the one that had drafted those to correct that. She did not do that. Which then necessitated us in filing this motion to have that child support corrected. I don't believe she's disputing that my client carries child support or carries medical insurance on the children. So our request is just that UCSO gets corrected and backdated to the original entry as to that's when my client was carrying the insurance and still does. And for attorney's fees, we're having to bring this to court when we did provide all of this information to Ms. Morris, and this could have been a very easily corrected, just change the UCSO and get that updated. Instead, it made us file this motion and have to have this hearing today in order to get this problem corrected that she should have corrected the first time when the front of the court identified it as a problem.
Okay. Mr. Robinson, what's your response?
Well, Your Honor, I'd point out that the my client didn't try anything or do anything underhanded here. The order in dispute was reviewed by the defendant and his attorney and approved for entry. The front of the court approved it for entry. Now, after the fact, he comes back and says, oh, I'm paying X amount on insurance for the kids. I think she's wanted proof that he's paying that much. I don't know. I haven't, whatever paperwork Ms. Jensen has sent to me, it isn't showing up in my email anywhere yet. You know, and she would point out that when she calculated support, she reduced his income by $3,000 to $5,000 per year. And she feels that's a sufficient offset, that support shouldn't be changed. And even if the court were to change it, since this wasn't her fault, she shouldn't be charged anything as a result.
Okay. Well, what the court's going to do is clearly, if he was in fact paying the healthcare insurance as alleged, and the court will accept that. What the court will order, however, is that the defendant would provide proof of carrying the insurance and the cost to Mr. Robinson's office within 14 days of today's date, that the court would order the correction of the UCSO to include that healthcare insurance cost. But again, as stated by Mr. Robinson, obviously it was provided to the defendant and the defendant reviewed it. Counsel apparently reviewed it and missed this. The court's not going to, again, make her pay any attorney fees in this matter as a result. So the court will deny the request for attorney fees. And I'll ask Ms. Jensen that you would prepare an order reflecting that ruling.
Yes, Your Honor. Just to clarify, the pay stubs that I had sent to Mr. Robinson on Friday were the ones that were used in the calculation that had been provided to Ms. Morris back in May and in June. Are you wanting us to get updated ones, or are those sufficient since that was what was used at that time?
That would be sufficient, and the court will take the modification back to the date of the original order, provided that he's been paying the insurance that entire time.
Yes, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Bruce Mills versus Lauren Evans.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Nickerson on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary parenting time and custody. Go ahead, Mr. Todd.
Thank you, Your Honor. Your Honor, I will also address the counterclaim and the answer. In this particular case, the parties facilitated parenting time since the child was born until the defendant abruptly left Michigan and moved to South Carolina in late October. After that, we promptly filed this case. However, we were unable to have the defendant served because we had no idea what she was. Eventually, she was served because she hired an attorney after we sent out subpoenas to her parents. It is not disputed that the child was living in Michigan up until that point. What is disputed is the amount of time that each party had during this period. The status quo with parties prior to the move was that plaintiff would have 6 days a week during the summer and 1 overnight during the week, along with Friday through Monday morning during the school year. We have text message verification of this. That text message states as an offer of proof, what do you want me to do? The opposing party says, and my client indicates, I want you to be a mother. She asks, is this what happens when mommy gets a boyfriend? It has been just 2 days of 6 that she has seen you. Additionally, we believe it is odd that upon the defendant leaving, this is the first indication that Mr. Milnes isn't able to have custody or parenting time. If this was the case, she could have and probably would have filed this significantly earlier. In terms of the allegations contained within the counter complaint, defendant has been diagnosed with borderline personality disorder, bipolar, and has been prescribed lithium. As far as drug use, both parties previously struggled with drug use. However, plaintiff got sober in 2017. He takes a drug test every month. Conversely, defendant has recently, as of this summer, asked him for Oxycontin, which he was prescribed for back pain. We have text message verification of this as well. The plaintiff has had various jobs, however, he does have consistent employment. In relation to domestic violence and alleged abuse, this is inaccurate. There was a PPO in 2018 or 2019. My client's aunt died and the parties got into an argument whereby defendant elbowed my client in the face and he subsequently did pull her hair. There was a PPO in place for 3 months and he tried to get her served, but just like this case, he was unable to do so because she was hidden. Eventually, the parties got back together, and I apologize in my response. The PPO did not get dismissed. That PPO ran its course, but was never enforced. The police have not been involved with anything between the parties. There was an issue where the police were involved, where the house is broken into. There's a question about marijuana growth, which was in defendant's name, and defendant's father at one point took a firearm from my client. However, there has been no police involvement for something between the parties. Additionally, in terms of seeing doctors and dentists, my client was involved to the extent that he was able to be involved. He continued to push to have the child to attend doctors and dentist appointments. However, defendant would say that she didn't want him to, and she was going to do that with her parents. He didn't mind this as long as it got done. However, it was him consistently pushing to actually have the child go to the dentist and doctor. The majority of the response is either embellished or inaccurate. However, it's not disputed that the child lived in Michigan up until late October. And we are respectfully requesting that the court have the child promptly returned and that the parenting time, the status quo of the parenting time prior to the child leaving be resumed, and that defendant complete a psychological evaluation and comply with any recommendations.
Thank you. Ms. Nickerson?
Thank you. From the affidavit of parentage on, my client was always presumed to be the custodial parent, and she says she always was the almost sole parent for this child. She, as well as her mom, and I've talked to her stepdad, have all confirmed that she was the one who had Harper in her care almost all of the time. What would happen is my client was the only one working. Mr. Milnes had worked 2 months at ABC Warehouse when my client was pregnant. Other than that, during any time that the parties were together, he never was able to hold a job. And so my client was the one out working, and her mom and stepdad and aunt would help provide daycare, even when the parties were together, when needed. But she would have Mr. Milnes or ask him to provide care, typically 1 day a week, sometimes 2 days per week when she would go to work. She would not have felt it safe for Mr. Milnes to even have that amount of contact, but for the fact that his parenting time is exercised at his parents' house. He has never, as an adult, been able to maintain employment or housing of his own. And my client indicates whether it's because of untreated bipolar disorder or substance use issues, he mostly stays in his room. My client is able to identify to me and verbalize a long history of domestic violence that she suffered at the hands of Mr. Milnes. She has been able to provide me a copy of the personal protection order that was granted against Mr. Milnes to protect her, that was in place from 2019 to 2020. The parties did not reconcile after their separation in 2019, and that personal protection order was granted and remained in place. My client further provided to me a video that I did forward to council, which is a video of the incident in April of this year, where Mr. Milnes was having a public visitation with the party's daughter and got into a physical altercation with a stranger, a woman at a dollar store in Battle Creek. My client is terrified of him knowing where she's at. She did leave the state. I thought it was the beginning of October, which she had the legal right to do. She notified Mr. Milnes the day she left and explained to him the reasons why she did not feel contact between him and Harper was in Harper's best interest. And almost all of that relates to his violent past and his violent behavior both towards my client, but also in the presence of Harper. The final straw for Lauren was when she went in September for a parenting time exchange. Mr. Milnes came out of the house screaming with his hands up, charging towards her vehicle, and she drove off with the minor child and called her parents to pick, she took her daughter to work and had her parents or her mom and stepdad pick Harper up from work. She's just too scared of him to try to arrange any contact at this point in time. My client denies that she's ever been diagnosed with bipolar disorder or borderline personality disorder. She did suffer from postpartum depression and also from post-traumatic stress disorder is what it was eventually diagnosed as. She is willing to release her medical records from Summit Point, which is where she had treated when she was in Michigan. She's willing to undergo an evaluation if the court deems that to be appropriate, but she would ask for Mr. Milnes to undergo an evaluation as well. My client does not feel safe at this point with Mr. Milnes knowing where she's at. She also does not feel it to be in Harper's best interest to either be forced to return to the state of Michigan or to have contact with Mr. Milnes until an evaluation of him can be conducted and until we can have further hearing, for the reasons both included in my pleadings as well as what I'm indicating today. Harper is doing well. She is enrolled in school. She is in gymnastics and has made friends where she's at. My client at this point in time is able to be a stay-at-home parent to Harper, which is something she had always hoped to do. But because Mr. Milnes was not willing to provide care or provide financially at all for Harper during the course of her life, except once in a great while, my client says she can count on one hand, he gambles. And so he gambles online, and if he would have winnings, she said there had been some times he'd give her some money from that. My client denies having any substance abuse issue. It was actually Mr. Milnes who had used pills and heroin and then has been on Suboxone for 5 years. My client indicates that the one thing they can try to say against her would be she legally did grow marijuana for a period of time when the parties were together, but that was because Mr. Milnes refused to work and she needed to help supplement her income to be able to provide for the family. She's willing to drug test if needed, but we don't believe that there's a sufficient basis alleged or argued that would warrant that. We're asking the court as temporary relief to award my client sole legal and physical custody of Harper, to suspend contact between Harper and Dad at this point in time, and then to order such evaluations as the court believes would be appropriate while we wait for further hearing. Thank
Okay,
you.
Thank you. Sir Todd, what do you think as it relates to evaluations in this matter?
No objection, Your Honor.
Okay. I'll leave that up to the attorneys to arrange that. Then the parties can get a psychological evaluation. Both of the parties, then that will be, the reports will be released to the other parties. The court obviously is confronted with diametrically opposed positions and evidence in this case. So the court is not going to make a determination of custody until such time as the court can have a evidentiary hearing in this matter. So the court will set a short parties only testimony evidentiary hearing, and I'm going to try to get that set up in January. So I'll tell both of the attorneys, make sure that you have some time available, because if we can't get any time set up with the both of you, then the court's simply going to set a date and we'll do it at that date. But we'll be in touch with you probably by tomorrow to see your schedules and see when we can set that up. Okay?
Your
Okay,
Honor,
that's what we'll do, and we'll see you back then, and try to, if you can, the two of you get together and see if we can't expedite the evaluation so we'll have those at the time of the hearing.
Your Honor, do you need me to create any order?
Yeah, why don't you create the order calling for the evaluation and the short parties only evidentiary hearing.
Okay, absolutely.
Okay, thank you.
Thank you, Your Honor.
I will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion for Christmas parenting time and other communication. Ms. McNiff.
Your Honor, just for the record, my client has remarried and her new last name is in fact Tinsman. The record could reflect that. We're here only for two matters, although the answer delved into a great deal of other issues. One is to, just for this Christmas vacation, to modify parenting time. The parties did in fact sign a consent order that modified parenting time because their judgment of divorce did not have the standard provisions in it, and it also didn't designate odd and even years. It left out like spring vacation. It was deficient in a lot of ways. And both Attorney Thomas and I agreed, and the parties agreed, that we needed to clean that up from the original.
Okay, Ms. McNiff, if that's been done, don't argue it, okay?
Oh, I'm sorry, Your Honor. I won't. I'm just trying to give the court a little background because I know.
I'll just tell you, I have an extreme amount of motions today, so I don't need extraneous information.
Okay, Your Honor, I apologize. So at any rate, at this point in time, my client is trying to move to West Virginia. We've been trying to work out a parenting time plan. We haven't been able to do that on our own. We're continuing to negotiate. And all she's asking is for a swap of 24 hours such that Mr. Gentry could have the children for Christmas Day and Christmas Eve, and he would have the first part of Christmas vacation. She would have the second part of Christmas vacation with the children. This would alleviate a lot of the back and forth, and it would give both parents a solid week. She's asking that he have what's generally considered the better holidays, both Christmas Eve and Christmas Day. And then she would bring them back at the end of the Christmas holiday in time for him to also spend time with one of the party's children who has a birthday near that end. It's, again, a 24-hour swap. It doesn't change the amount of parenting time either party has, and it would allow her to be in West Virginia with her husband, her new child, her stepchildren, and the party's children. We think it's a minor change, and it actually benefits Mr. Gentry. That's the first part of our motion. The second part, Your Honor, is we've had continuing problems in this case with the parties communicating about important issues with the children. For example, the one child spacers. First time we've gotten a response on that, even though it's been a pending issue since June, was in the answer to the motion. First time we've gotten any real answer on the sleep study for the 9-year-old who has a bedwetting problem was in the answer to the motion. The referee did recommend that the parties continue to use a parenting time app in order to communicate, and my client has continued to do that, but there are dozens of unread messages, and things like sleep studies and bedwetting and spacers and privacy concerns with the two of the children are all very important issues that the parties need to discuss. So we're simply asking that there be a response, even if it's, I don't agree with that and I don't want to do it, so that we know what's going on and how Mr. Gentry, what his position is on these issues, important issues that involve the children. So those are our only two requests today, Judge, that we have some kind of response on important child-related issues within 48 hours on the app, and that we modify parenting time for this year only to allow Mr. Gentry to have the entire first portion of the Christmas vacation, including Christmas Eve and Christmas Day, and that my client have the second portion.
Okay, thank you. Ms. Thomas, why would it not be reasonable if he gets Christmas Eve and Christmas Day? That would normally not occur.
Your Honor, the situation is such that every time that there is a change in the parenting plan that Ms. Gentry asked for, and Mr. Gentry agrees, it always comes back to bite him. And by that, I mean, it's either forgotten or now when she does agree and she does it, it's she's doing a favor for him or whatever. We have this order in place. It was put in place in July of 2024. He simply wants to follow it. He made his plans for Christmas break accordingly. He just simply wants to follow. He believes that's his only protection of making sure he gets all of his parenting time is to follow the exact court-ordered parenting time. He doesn't want to change it around. He made his plans accordingly, and Ms. Gentry can do the same. She signed the consent order that was entered. The court accepted it, approved it, signed it, and Mr. Gentry simply wants to go by the court order. There's no reason to not do that. We just had a 16-month period of going through a change of domicile. As part of that, the court looked at parenting plans and alternate parenting time, different things, and frankly, none of that was ordered or awarded. And at this point, there's no change in circumstances or proper cause, even from the entry of that order, which says what the holiday parenting time is going to be. There certainly is another custody-related order subsequent to that, or parenting-related order subsequent to that, and that was that Ms. Gentry asked for interchange of domicile for an alternate parenting plan, and the court did not do that. They did not believe it was in the children's best interest, and the court did not order that. That finding came out in October of this year. So after the holiday time, clearly the referee knew what the holiday time was. He knew it was by consent. He didn't change it. He didn't change any parenting time. And so therefore he's asking that, no, I just want to follow the court orders. Then I don't have to worry or wonder about, I'm not going to get my makeup time or whatever it's going to be, or the alternate time, because that's what's happened before. And he just has no intent or desire to do that because it's been a problem in the past, and there's a court order and he simply wants to follow the court order.
Okay.
As far as the communications issue, again, this was something that was brought up in the actual original motion for change of domicile. It was one of the specific requests, and the parties at one point had agreed on their own to use Our Family Wizard. It was never ordered as stated in the motion, and then the referee specifically, although recommended use of app close, not Our Family Wizard, did not order it. It's very clear in his finding that he recommended it, but he did not order it. He knew all of the problems, what the problems were, and Ms. Gentry has repeatedly asked for a response within so many hours. Mr. Gentry denies that there's dozens of unread messages for the reason it's not true. Again, this is Ms. Gentry attempts to control Mr. Gentry through the app, and he just doesn't prefer to do that. You have to answer within. She blows up his phone. That's the part of the communications, and it's interesting the reading of as what was put in the referee's finding about that they both believe what they believe, and he doesn't believe either of them lied, but they're at a very different perspective as to what they believe as far as co-parenting, and that ultimately one way of Ms. Gentry controlling Mr. Gentry, or Ms. Tinsman controlling Mr. Gentry, is through multiple, if there's an issue that's an issue to her, she'll send multiple messages as opposed to one and wait for an answer. That's not how it happens. And he just doesn't want to be required to answer within a certain period of time. And again, he would have to answer. He'd have to answer 10 messages within a period of time, maybe because she might send that many. Maybe she sends 3, then he'd have to answer 3. He just doesn't want to do that. He's not in favor. Again, the court suggested it, but the court certainly did not order it. And we're asking that not be ordered. And specifically, even if this court were to believe it better that it is ordered, to absolutely not put a time limit as to the response time, because it's overwhelming. When the way that Ms. Gentry attempts to do this is overwhelming.
Okay. Anything else, Ms. McNabb?
Our Family Wizard was in fact ordered in November of 2023. Mr. Gentry didn't like Our Family Wizard, wanted to go to app close, and so app close was recommended. But the reason my client sends so many messages is because they're follow-ups. Hey, how about those spacers? Hey, the doctor recommended spacers. Can you talk to me about spacers? She has to keep repeating it because she does not ever get an answer. And these are important issues. These parties have joint physical and joint legal custody. They have to communicate about the needs of the children.
Okay. Well, what the court's going to do is the parties did enter into a consent order in this matter. The court's going to, and apparently that was just sometime earlier this summer. And again, the court will continue the current orders. I'm not going to change those orders. The parties will have to live by them. They consented to them, and again, it's final in this regard. So the court will not modify that. I'm not going to order any communication app at this time. If it becomes necessary in the future as it relates to a particular issue, the court will consider it and would consider putting a time limit on it at that particular point. But there is nothing pressing at this point where that needs to be done, so the court will not grant that. Ms. Thomas, you can prepare that order.
Thank you, Your Honor. Is there a possibility of attorney fees because we
I'm
came here
not going to
without?
award. I'm not going to award attorney fees in this.
Okay, that's what I thought. Okay, thank you.
Thank you.
Thank you, Your Honor.
Larry Russell versus Danielle Swafford.
Court will note the appearance of Ms. McNiff on behalf of the defendant. This matter is before the court on the defendant's motion for an order concerning parenting time. Ms. McNiff.
Your Honor, as the court knows from our motion, Mr. Russell on Black Friday had a major seizure while he had the children in the Walmart store in Battle Creek. And at that time, he refused for the EMTs to take him to the hospital. My client showed up and took him to the ER. The ER doc indicated that they couldn't confirm or deny the fact whether he had a grand mal seizure, but did refer him to a neurologist. We have significant concerns about him driving with the children and being alone with the children because they're very young. They're 3, they're almost 4, until he is cleared from a neurologist and we find out what caused that seizure. At the time he bit his tongue, he urinated. It was a serious medical condition, and we don't know what caused it. We are simply asking that he have another adult present and somebody else to drive when he has the children. We're not asking for supervised parenting time. We're just concerned about the medical condition and the safety of the children. The children are too young to be able to call 911 or to take care of themselves. And of course, the concern about having a seizure and driving is concerning not just for Mr. Russell and the children, but for anybody on the road. So we're asking that he get in to see a neurologist as soon as possible. If he's cleared, then that can be lifted. If he's not cleared, then whatever measures he needs to take care of his medical condition needs to happen before he should be driving the children.
Okay, thank you. Mr. Russell, what's your response?
My response is Miss Swafford was there when they said that they don't know if it was a seizure or if it was vascular. So vascular is where you overheat and you pass out. So I just came from my primary doctor, and she looked at my charts, and nothing on there says that seizure was any of it. They're just saying fainting. So so I went to them, and at this point, I mean, she's saying grand mal. Does she understand what grand mal seizures are? Because yeah, that's the worst seizure you could have. And nothing on my paperwork released from that doctor at the emergency room and my personal doctor, my doctor I just came from, says nothing about seizure. It says about fainting and overheating. So the only thing that they could almost give it to is I've always had higher blood pressure, and they're saying that maybe that might be one of the things. But as far as getting into the neurologist, I called there, and if it was such a imminent danger, why did they not pull my license? Why am I still able to drive? And I have to drive to Kalamazoo to go see the neurological surgeon. So if it's seizure, then 6 months I would not have a license. So I'm just saying, let's not play doctor, because I've been to the doctors. And if they have cleared me both times, I don't understand what the issue is.
Okay, when you say they have cleared me, who are they?
The ER doctor, and then my personal doctor, my primary doctor today.
Your Honor, my client was at the ER and I don't believe that he was cleared. I believe the ER doctor sent him to a neurologist to try to figure it out. If it's blood pressure, then if we could get some kind of note, show that he's on blood pressure medication, that he's taking care of that so that he doesn't faint again. Whatever the condition is, it's not safe to drive with these kids until it's taken care of.
Okay. Well, what the court's gonna do is the court will order that, that if necessary, that basically the defendant, in this case, would provide the transportation to and from parenting time unless the plaintiff has someone else with him or somebody that can drive for purposes of doing that, but he will not drive with the minor children alone at this time till we have confirmation as to what his medical condition is. Court would order that the plaintiff would provide a report from his doctor. Again,
I can do that today.
you provide that to Miss McNiff within 14 days as to what the problem was. And if in fact the doctor cannot establish what the condition was or the problem, that the plaintiff would see a neurologist within 45 days and provide a report to the
I have an appointment for January 2nd.
Okay, well, good. Well, we can, you can see the neurologist on the 2nd and then have the neurologist provide a report and provide that to Miss McNiff.
Thank you, Your
So
Honor.
what so I guess what is it? So she has to drop him off to me at my house and I can't go anywhere with him?
Right, you cannot drive alone with the kids in the vehicle. You'd have to have some other driver with you until we get the matter cleared up.
So here's my question though. If the doctors have cleared me to drive, so I'm going to get a third opinion pretty much. But so the emergency room, my primary doctor, and now I'm going to a neuro January 2nd. But what I'm wondering is if they cleared me to drive, why can I not drive my children?
Well, because we're not
no
certain,
restrictions.
and neither Miss McNiff nor myself have looked at any reports from any doctors. And until that happens, I'm saying you're not going to drive with the kids. So if the neurologist gives a report and says he didn't find anything and you're capable of driving, then the court will remove that restriction.
Okay.
Okay. Ms. McNiff, you can prepare the order and submit under 7 day.
Thank you, Your Honor.
Okay, thank you.
Andrew Katie versus Ella Graff.
Court will note the appearance of Mr. Vanderhorst on behalf of plaintiff, Ms. Redmond on behalf of the defendant. This matter is before the court on the defendant's motion for entry of judgment. Ms. Redmond, go ahead.
Thank you. Good morning, Your Honor. So as was stated in the motion, in this case, we had mediation back in early October, and the parties came to a complete agreement that was reflected in the mediation status report that was submitted to the court. And an order regarding custody, parenting time, child support, and a uniform support order was drafted and approved by a friend of the court. I have signed it, and a defendant has signed it as well, and I have sent it over to plaintiff and plaintiff's attorney to be signed. It has not been signed yet. I am asking now that given the time frame that has passed since we came to that full agreement at mediation, and there has been no signature, that it be that this order be entered under MCL 2.602B4, or in the alternative that we set it up for 7-day notice to be entered then. Thank you.
Okay, thank you. Mr. Vanderhorst?
Yes, thank you, Your Honor. Good morning. That is true what Attorney Redmond is saying. We did reach a full settlement with the help of John Brundage, Attorney John Brundage, on October 17, 2024. The order is an accurate representation of that agreement. Other than the problem that my client has, Your Honor, is calling this a final order because we are going to revisit this in maybe 4 months from now. It says 6 months from the time we had mediation, I believe, and revisit the parenting time issues at that time. So that's our only really hang up on this, Your Honor. So I'll leave it to your discretion what you want to do here. But
Well,
that's-
is that review in 4 months reserved in the agreement and reserved at the time of mediation?
Yes, it says that the parties shall revisit mediation in 6 months upon entry of this order in order to address parenting time needs.
Okay. Well, the court will enter this as a final order, but obviously the final order provides for a review, so there's no reason we can't do that.
Okay.
Okay?
Very good.
Okay.
Thank
and,
you.
Ms. Redmond, do we have the order too?
Submitted it attached to my motion, so it
Okay.
should be available for signature now.
Okay.
I just sent it.
Okay. We have that. We'll get that entered.
Okay, sounds great. Thank you very much.
Have a good day.
Yep.
You
Thank
too.
Your Honor.
Terrence Butler versus Christine Gray.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time, and support. Ms. Reed.
Thank you, Your Honor. I'm going to primarily rely on my motion. The parties share one minor child who's 7 months old. The plaintiff has been refusing to communicate on a very basic level regarding this minor child, which has caused my client to have to leave work early. He refuses to arrange appropriate times to exchange the child when he does exercise parenting time during the week. And then when he doesn't appear, he intends to berate my client if she's not there hours later to exchange the child. My client does have concerns regarding the minor child in his care during the week as he works thirds and he's either sleeping during the day or not sleeping and caring for the minor child instead. She works first shifts. The only time he's been real consistent in exercising his parenting time is he has been doing overnights on alternating weekends. And so she's asking for sole legal custody, sole physical custody, and for the plaintiff to have alternating weekends with a midweek visit and child support pursuant to the formula.
Okay, thank you. Mr. Butler, what's your response?
My response to that is false. I've have our child since Miss Gray went back to work 12 weeks after having a baby. I get the child after work at 7:05 when I was going to her house. So I would go leave work at 7:05, get there by 7:30 and pick up the child. Take her home. And then we have our normal routine for the day. I nap when she naps. That's a sacrifice that I chose to do prior to her having a baby. I decided to go on third shift from a first shift in order so we can have a bond with our kid. As far as me falling asleep or being too tired while our daughter is in my care is false. Like I said, I nap when she naps, and I am okay with that because I can lay down later in the day, So as far as making her miss work or making her late for work or leave work early, that's also false. I get there, like I said, around 7:30, depending on traffic. When I do get to her house, the baby is never ready to go. She's always in the bed asleep. And then Miss Gray is still getting around to get to work. So her leaving early for work, she at our job, we work at the same place. So at her job, they are okay with salary workers to, let's say they get in 7:30 a.m. They can leave at 8 hours later. So she's not coming to work late or on time and then leaving early to to get in trouble for that. She's not doing that. She's working her 8 hours and coming to pick up the child afterwards. Then also my son, through my marriage, I started playing basketball. So his games are at 4 o'clock and practice starts at 4:20.
Okay, sir, is that a child by another relationship?
Yes, sir.
The court will not consider anything as it relates to that child that would
Okay.
impact this. So
Okay.
what
Okay.
happens if that's the case, and it's unfortunate, you'll have to work that out yourself.
Okay. I understood. Did I miss any points?
You tell me, sir, if there's anything else you'd like to say.
Yeah, as far as me being inconsistent, I've had our daughter after work since I had initiated the whole case, where she eventually allowed me to see our daughter again from keeping her from me. So I've had her since then, after work till the time she gets out of work, because I'm okay with just being able to see my daughter, see our daughter. Yes, I would like more time, equal time with our daughter. But I'm just okay with how everything is right now. I'm just cool. I'm not trying to start no arguments or anything like that, so I'm okay with it. Prior to that, when she was on maternity leave, we also watched our daughter together. It was never like I was never over there at all. I actually left work and I would go over there and watch our kid with her. So I've always been an active parent since day one, throughout the pregnancy, everything. And I would like to continue to be an active parent through the breakup.
Okay, thank you. Anything else, Ms. Reed?
Your Honor, my client can't come and go to work as she pleases. She is at risk of losing her job if this continues. She can't go in whenever she wants and leave whenever she wants. She needs to be able to have a consistent schedule for this child so she can arrange for appropriate child care. She has been the primary care provider for this child since the child was born, all through maternity leave and afterwards. She has the vast majority of overnights with the child, and like I said, the only time he is really consistent with exercising any overnights is on alternating weekends.
Okay. Well, what the court's gonna, I'll ask Mr. Butler, what's the time? You're saying that you get out of work so you could pick up the child by 7:30, correct?
Yes, sir. So she actually asked her job to change her schedule from 7 to 3 to 8 to 4 in order for me to have enough time to get to her house to pick up our baby. So she's working from 8 to 4. And even now, since we had an incident where she accused me of making her late for work, which I never did, I suggested that she drop the baby off at work to me, and she can go to work from there, because that way she can never be late, correct? So she still shows up to work late. I remember just recently her coming to work around 8:10 in the morning, which is late, and I'm not jeopardizing her job at all. If anything, it's the other way around.
Okay. Well, what the court's gonna do is, it sounds like the parties did have for a period of time, and for some time, we're working where the child would be with the defendant, other than the time during her work, which may, whether it's 7 to 3 or 8 to 4, where the child would be with the plaintiff. What the court's gonna do is award the parties joint legal and joint physical custody. Parenting time will be with the plaintiff from 7:30 a.m. until the defendant would pick up the child from him within 1 hour after the end of her work. And then the parties would alternate weekends and alternate holidays as well. And then support would be consistent with that parenting time arrangement. Ms. Reed, you can prepare that order and submit it under 7-day.
Who starts the rotation since we have Christmas coming up?
Excuse me?
Who starts the rotation for holidays as Christmas is coming up?
Who had Thanksgiving?
The mother.
Okay, well then defendant or plaintiff would get Christmas Eve, and we'd alternate from there on.
Thank you, sir.
Yeah.
Okay. You can prepare that and submit under a 7-day order, Ms.
All right,
Reed?
sir,
Excuse me?
I have like one question.
Go ahead.
I had volunteered myself to come to third just for the on calendar year. So I will be going back in January, 2025. So for the time being, through I guess up until that point, are we going to continue to do what we're doing now, or?
Well, I just ruled what you're gonna do now.
Yes.
If your schedules change, you'll have to come back and file a motion if you can't get an agreement.
Okay, sir. Thank you.
Okay, thank you.
Courtney Hauser versus Nicholas Hauser.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on two motions, the plaintiff's motion for temporary suspension of parenting time and modification of custody and parenting time. Go ahead, Ms. Reed.
We addressed a request for modification of parenting time and custody at a motion hearing last week. And then I received a notice that the ex parte order, we were sent the wrong ex parte order that did not have today's hearing on it Friday. And at last week's hearing on Monday, the court had ruled that any parenting time for the defendant was going to be occurring in Michigan, and he was going to be making mom available to medicate Tristan during his parenting time. It is currently set for an evidentiary hearing February 11th. It's my understanding the defendant's next parenting time isn't until spring break next year, and hopefully we have the issues resolved by then. So in the meantime, I believe the issues have been appropriately addressed. It's also my understanding that Mr. Hauser did not get our pleadings until after the hearing, as there was some confusion about his last known address. And so I need Mr. Hauser to contact my office with an email so we can email the pleadings to him, because right now, since he's in Florida, he's not going to get anything timely.
Okay. Mr. Hauser, what we'll do is have you contact Ms. Reed's office. I don't want to put it now because it'll go out to the public, and provide her with your email so that she can, again, get service upon you that way when she can't send it to you vis-a-vis mail, okay?
Yes, sir.
And that order, again, so, Ms. Reed, I thought when I looked at this too, I thought, well, that order kind of took care of the issues in this matter.
And I noticed that order from last week out on Friday, and so Mr. Hauser's probably not going to get it within the 7-day objection period, but I will email it to him.
Okay. Anything else, Ms. Reed?
No.
Mr. Hauser, anything else?
No, sir.
Okay, thank you. You're free to go. Have a good day.
Jared Yeomans versus Christina Yeomans.
Court will note the appearance of Mr. Umloff on behalf of plaintiff, Ms. McKenzie on behalf of the defendant. This matter is before the court on the defendant's motion to adjust Christmas parenting time and allow out-of-state travel. Go ahead, Ms. McKenzie.
Thank you, Honor. We are asking the court to adjust the parenting time per my request in paragraph 9. And the parties have cooperated through a consent order from the summer in terms of parenting time. And most recently, at Thanksgiving, my client wanted to take the girls. It was her turn for Thanksgiving anyway. She wanted to take the girls to Indiana to her sister's home for the Thanksgiving dinner. And Mr. Humans did permit that and corresponded by text and so forth with the girls while they were, checking to see if they were having fun and so forth at their aunt's house during that Thanksgiving break. So the court had a chance to read the motion?
Yes.
I know the court has had a full schedule today. So what I'm just going to go to my paragraph 9, which should have been paragraph 10. We are proposing that the
I got that. You don't need to go through that.
Oh,
Mr. Umloff saying that she's living in Michigan, so why does she need to go to Arizona?
She's not living in Michigan. She's been an Arizona resident and has voted in Arizona, has had a driver's license in Arizona since the spring, March or April. I don't recall exactly when. But she is staying here with her aunt pending the outcome of the custody case and the divorce, Your Honor. That is the only reason that she is here. So she's staying with her aunt and alternates time between her older daughter and her aunt, but primarily she's staying with her Aunt Dorothy, who is known to, and this is known to to Mr. Humans also. So she's a resident of Arizona by virtue of driver's license and by virtue of her voting status also. So
Is she
but she is
exercising
staying.
parenting time here in Michigan though?
I'm sorry, Your Honor, there was a disconnect between what I'm
I'm
seeing.
saying, is she exercising parenting time in Michigan though?
Oh, yes.
While she's here.
Yes, she is.
Well, then why does she need to go to Arizona over Christmas?
That is where she has friends. She is searching for a school-related, bus-related job down there, and in fact has several offers. And it would be a nice break for the children to be able to go to Arizona. They enjoyed their trip to Arizona earlier this year, and they should see where the mother is residing after the decision is made. This is the spot that I'm in and that Miss Humans is in, is that we were anticipating that this would be decided, and unfortunately it can't be. That's fine. That's the way it is. We understand, and the court did work us into the calendar early in January. But the change of domicile is also before the court, along with the custody, parenting time, and at this moment, the property issues also for the divorce trial. So the children need to be familiar with the spot that the mother is planning to reside in, and the mother would like to go to Arizona for the Christmas holidays also. And she'd like to firm up some an employment offer from one of two schools. She's been offered positions with one of two schools. And as the court may recall, she's a bus driver, has bus driving experience for around 10 years here at the Lakeview schools. So she is staying temporarily, honoring the consent order that the parties came up with, honoring the order of the court earlier this year to keep the children here in the state. And as a practical matter, the parties were able to agree on a 2-week out-of-state vacation, authorizing each party this summer to take the girls for out-of-state experiences. And that's what we're asking for right now, especially during the holidays. But what happens, the net effect of this is that the father gains time. He's gaining 3 days before Christmas, plus he's gaining Christmas Day.
Okay, well, let me ask Mr. Umlauf. They're proposing that your client would have the children on the 19th, 20th, 21st, the week of the 22nd, up through Saturday on the December 28th, and she'd have the children from December 28th through January 5th. It does appear it gives him more time, and he has Christmas Eve and Christmas Day. So why is he opposed to that?
Your Honor, given it, and I think our response speaks for itself, but given the closeness we have in trial, we do have concerns that the defendant will simply stay in Arizona, given how close we are to trial and how difficult it would be between now and the date of trial to get an ex parte motion filed to have the children returned to the state of Michigan. My client, I would note for the record, did not give permission for the defendant to take the children to go to Indiana. She did so without his agreement and therefore in violation of the court order. Earlier this year during the summer, my client initially requested to take his 2-week summer block of parenting time during a time period that would have also
Okay.
I'm sorry, I didn't hear that last part, Your Honor.
He's froze up.
Oh, all right. I was slightly concerned that it was my technical issue once again.
No, usually it is, but not today.
I know.
state of Arizona. She's been living
Mr. Umlauf, you cut out, you froze, so I think about half of what you said we didn't get.
Okay, what was the last thing you did here?
You said about you're not agreeing to Thanksgiving, and then you were talking about the 2 weeks, and that's when it stopped.
Okay, apologies. My client had requested to take his 2-week summer break during a time frame that would have included the beginning of the girls' school year. He requested that the defendant agree to that. She refused, even though he assured her that the children would still be able to attend school during that time frame. So it's interesting that now she's asking for a modification of the holiday schedule. So for that reason, we are opposed to the motion. We request that it be denied together with costs and fees. Thank you.
Okay, thank you. Well, it does appear in this matter that the plaintiff doesn't have any substantial dispute as to changing the time, and it does afford him with more parenting time. So I can't imagine why he would object to that. The court will allow the change in the parenting time for this Christmas, where the plaintiff would have the 19th, 20th, 21st, and the week of the 22nd up through 9:00 a.m. on Saturday, 12, 28, 24. And then the defendant will have the children from 9 a.m., 12, 28, 24 through 6:00 p.m. on January 5, 2025. And I will state, court doesn't have an issue. She's taken them out of state and brought them back. The court would order that the children would be returned in the state of Michigan on the January 5th, 2025 at 6:00 p.m. Obviously, if she doesn't, the court will enter an order having the children returned. She subsequently will be held in contempt of court, and she could go to jail if the children are not returned on January 5th. And Ms. McKenzie, you can put all of that in an order and submit under 7 days.
Thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Saranda Smith versus Devin Daniel.
Court will note the appearance of Mr. Hilderly on behalf of the defendant. This matter is before the court on the defendant's motion for entry of the final order and the UCSO. I would note, Ms. Smith, the court has previously been informed that you did not yet pay the mediation fee. Have you paid that mediation fee?
I'm currently not working and haven't been working since I was pregnant with this little guy.
Okay.
And have not been able to work. So I don't have a way to pay anything right now on a mediation fee.
Well, what the court's going to order that you pay that mediation fee within 30 days of today's date, or the court will hold you in contempt of court. So you need to get that paid. Mr. Hilderly, you can proceed with your motion.
Thank you, Your Honor. To refresh the court's memory, we were here before Your Honor on November 4th, seeking to enter this order and refer the matter to friend of the court. Your Honor indicated that rather than do the referral, that he asked us to prepare the calculation for child support, and indicated what he would like the plaintiff imputed at. We have completed that calculation. Unfortunately, there's a little bit of an issue with getting my client's contact or income information. He's started a new job, but we've now completed that calculation and have presented a final order, which includes uniform child support order. So it is a complete order and could be signed at this time. We're just asking the court to enter it accordingly.
Okay, thank you. Ms. Smith, you received those orders in this matter. What's your response?
I received the paperwork stating for this court date today. That's all I received. And I was figuring I could talk at this court date, and the fact that I'm still currently not working and trying to get a job since I'm having the infant. So.
Okay. Mr. Hilderly, when did you provide those orders to Ms. Smith?
Should have been included with the motion. Looks like the motion was sent out looks like November 25th is when everything went out.
Okay, why don't we do it this way? Mr. Hilderly, what I'll do is I'll have you submit those final orders to Ms. Smith under a 7-day notice of entry. Ms. Smith, you'll get those orders. You'll have a limited time. If you have an objection to those, you're going to have to submit that objection within the 7 days, okay?
Okay. I received the orders ever.
Excuse me?
I said if I receive the orders ever, they have fun sending orders out that I never end up receiving.
Well, that's why I'm giving you this other opportunity to get the orders. So he'll send those out to you. And then from the date you receive those, you'll have, or from the date of mailing, you'll have 7 days to object if you have a basis for objection.
Okay.
Okay. Thank you. You're free to go. Have a good day.
Akiva West versus Craig West.
This matter is before the court on the defendant's objection to the referee order in this matter. The objection states that, again, the child is 100% in the defendant's care, and the parties had wanted to opt out of front of the court services in this matter. I'll ask Mr. West and Ms. West, in this matter, are either of you receiving public assistance?
No.
No, sir.
No, sir?
No, sir.
Okay, ma'am, are you?
No, I'm not.
Okay. Because we could not opt out of this front of the court services if there is public assistance in any way. I mean, if there's the children are on Medicaid, there's any food assistance, anything else. So, Ms. West, you're saying that children are not on, or the child is not on any of that, correct?
That is correct.
And Mr. West, you're not aware of that?
No, sir. They're not on anything that I'm aware of.
Okay. Ms. West, are you in agreement that, as Mr. West stated, that the child is in his care, in custody?
Yes.
Okay. Well, what I'll do, Mr. West, I will let you do an order. You can prepare an order stating that the child is in your custody. And you can state in there that that the parties are opting out of front of the court services in this particular matter. And on that basis, the front of the court should not have any other objections other than you are going to have to submit the order to them, providing that the child would be in your custody, okay?
Yes, sir.
That way they can check to see if there is any other public assistance that we're not aware of, and so that you just get a report back to the court. And then do the opt-out as well. You don't have to do a motion to opt out because effectively the court's taking that into consideration here. You can just do an order to opt out, get Ms. West to sign both of the orders, the one on the motion or the order of custody and the order of opt-out, and then you'll be able to submit that to the court, okay?
Yes, sir.
Okay.
Can I ask you one question real
Sure,
quick?
sure.
Once I place that order in, are we gonna have to go back in front of the referee just to let them know the circumstances?
No, once the order's entered, the referee will get a copy of that, and there won't be anything that the referee has to do.
Okay.
Okay.
Thank you, sir. Yes,
Okay,
sir.
thank you.
Yep, have a great day.
Have you too.
Thanks, sir.
Thank you.
Healthy Daniel versus Edward Daniel.
Court will note that this matter is before the court on the plaintiff's motion regarding custody. I note, Ms. Daniel, in this matter, you have received a report that you have not paid the mediation fee to Ms. Wadnicki. Is that correct?
Yeah, I was trying to get her number and stuff.
Okay, well, what's going to happen is the court's not going to take up your motion until such time as you pay that mediation fee. So you get the mediation fee taken care of, and then you can renotice the matter. Okay?
Okay, how much do I owe?
I don't know. You'll have to talk to Ms. Wadnicki. It just shows on the report that you hadn't paid. I don't know the amount.
Okay.
So you can renotice it after you have paid that. Okay, that's all we'll do today. You're free to go. Have a good day.
You too,
All right. Thank you. Oh my goodness.
Jose Cervantes Jr. versus Kaylee LaBeouf. Today is Monday, December 16th, 2024 at 11:13 a.m.
Court will note that this matter is before the court on the plaintiff's motion for parenting time. Court notes when I reviewed the file, it does not appear that there's any prior order for custody or parenting time. So the intent of the court would be to refer the matter to the referee for a hearing on the issues of custody and parenting time, and well, on child support as well, so that the referee can make a determination. Is there anything else you have, Mr. Cervantes?
So, Your Honor, I am getting those documents approved through Friends of the Court right now. I haven't had time to go down there and send it to the court clerk, but those
Okay.
are in process right now.
Okay, well, once we have them, I mean, you file the motion. Court can't take them up if I don't know what's in the orders. So
Right,
you have to get those matters filed.
Right, Your Honor. Presenting stuff, so it's a process. I was wondering if there's a way the court can appoint me an attorney.
No,
So
we don't
it's easier for
we
me.
don't appoint attorneys in these matters.
Okay, well then, so I have to put another motion in for parenting time after I approve those front of the court.
Well, let me ask Ms. LaBeouf, what's your
Paper.
position in this matter? You're muted, ma'am.
I'm sorry, what did you say, Your Honor?
What is your position concerning the motion for parenting time?
So my concern with the whole motion is that his first address he filed under has a felon in the household, and then the other address that he just filed under, the North 25th Street address, has an alcoholic in the household.
Okay.
And I have a PPO. I do not feel comfortable with my child being in unsupervised with him is what I would like.
Okay, well, what happens, we can take that up. I don't know what's gonna come up in the order, so. Have the two of you agreed upon what you're doing for custody and parenting time? And that's what's the order he's preparing? Or how's this come about? Because I don't see anything in the file.
So originally we were doing weekends only, and he asked me to try week on, week off, and I told him I would try it. I didn't feel comfortable with it because of the way my daughter was coming home and acting. She was spacing out and acting like everyone was ignoring her. She just wasn't acting normal.
Okay.
And
Let me do this. I'm gonna refer the matter to the referee for hearings on custody, parenting time, and child support. You can have a hearing and present all of your evidence at that time. Okay? Okay.
Thank you.
Thank you. You're free to go. Have a good day.
You as well.
Thank you, Your Honor.